Judicial review seems like a pretty major power, right? Um, Basically gives the court the power to rule any action of Congress or the president unconstitutional. That's the final word, right? If it's unconstitutional, it can't happen, we're done. But actually, it's a little more complex than that, and there are limits on judicial review. For example, I gave the definition as it basically allows the court to rule on any action. But that's not entirely true, right? We know that the court can only rule on things that are in front of them. And for a case to be in front of them, there are certain criteria that have to be met, right? The people involved need to have standing, for example, standing to challenge the law. And various other concerns and doctrines need to be met for the case to even be heard. So it's not all actions, but it is any action, so long as that action eventually gets in front of the court. Now, once it's in front of the court and they've heard the case, and let's say they rule the action of Congress or the president unconstitutional, well, that's it, right? Actually, no. Judicial review does not foreclose effective responses from other branches. So one effective response is to change the law that was ruled unconstitutional. We saw that recently with President Trump. When he issued immigration bans that the court said were unconstitutional, he just rewrote the executive order, issued a new ban, and the court ruled it was unconstitutional. So he did it again and changed it again. And that time the court said, yeah, okay, you're right, it's constitutional now. You fixed the problems. And we see that happen with Congress as well. In fact, one study showed that in the 70s and 80s, Congress actually passed an average about 12 laws a year that were specifically designed to tweak things to get around judicial rulings. So the political branches can offer effective responses to the court saying, no, this law is unconstitutional or this action is unconstitutional. Moreover, they can just ignore the rulings. The classic example of this is President Jackson, but we've also seen it much more recently in Congress. For example, the ruling of INS v. Chadha, the court in essence said that this procedure that Congress was using to allow one chamber to rule on this very specific, act, I should say, on this very specific law and allowing them to basically approve or not certain immigration provisions and just be one chamber. That's unconstitutional, right? We know everything has to go through both chambers. But this was a highly technical thing, and it was easier for Congress to only have this go through one chamber. So even though the court said, no, this is unconstitutional, Congress kept doing it anyway. They just completely ignored the court. And this can happen from time to time because the court can't enforce their own decisions. They depend on the political branches, especially the president or executive branch that executes the laws to enforce the laws. But if the president and Congress don't want to carry out the ruling, they don't really have to. They typically do because the public really doesn't like it when the political branches just ignore the law. But at least from time to time, they have just ignored the rulings anyway. Now, court rulings are also not permanent. The political branches, like I said, can modify things, and that can go from just tweaking a law all the way through changing the Constitution, right? The Constitution can be amended. So if the Supreme Court, for example, has ruled that flag desecration, flag burning, is protected by the First Amendment. It's part of our freedom of expression guaranteed by the First Amendment. So Congress has proposed, as we've talked about before, amendments to the Constitution that would make flag burning unconstitutional, that would remove it from First Amendment protections. If Congress specifically carved out this exception, said flag burning is not protected by the First Amendment, and attached that to the Constitution itself, and then the states approved that amendment and ratified that amendment, the next time someone tried to make a law banning flag burning, if that got to the Supreme Court, a case about that got to the Supreme Court would then rule, well, yeah, it is constitutional. Very explicitly, the Constitution says that flag burning is not protected. Therefore, any law preventing flag burning must be constitutional. But we know amending the Constitution is really hard. So this does not happen very often, but it can happen. Finally, the court itself can modify their own rulings, change their own interpretation of the Constitution. A classic example of this is the pair of cases, Plessy versus Ferguson and Brown versus Board of Education. In Plessy versus Ferguson, the court said, in essence, separate but equal was constitutional. But in Brown versus Board of Education, they reversed their position and said that separate but equal was inherently unconstitutional. So we see then that there are many sort of limits on judicial review. Judicial review is not always the last word. It is still very powerful. It makes the court strong, but it is not all powerful, right? There are, again, limits on judicial review.